in 2 broken window panes, and 1 student, namely Mr. P.E., who sustained an injury under his right eye. The injured student was immediately given first aid and has since made a full recovery and returned to school. Police were called to the scene and conducted an inquiry, which is underway. Mr. Deputy Speaker, sir, in response to the recurring nature of these incidents, the Director Zone 1 of my ministry, the Directorate, conducted a survey to assess the infrastructural vulnerabilities and student safety protocols. As a result, several infrastructural upgrades are being recommended, including raising the boundary wall between the 2 secondary schools and installing perforated iron sheets atop the wall to act as a physical deterrent. These measures aim to ensure the safety and security of students of both institutions. Mr. Deputy Speaker, sir, with a view of preventing similar incidents in the future, the Zone 1 Directorate has also recommended a series of remedial actions. Rectors from both schools have been advised to conduct sensitization sessions to, first, promote proper behavior, 2, encourage positive conduct, and 3, employ restorative practices to resolve conflicts. Mr. Deputy Speaker, sir, moreover, mediation sessions between students from both secondary schools will be introduced to eliminate hostility and foster mutual respect. This has not been done over the past 10 years. We are going to do, most probably next week. Close monitoring at sensitive points, especially near boundary areas during break and dismissal times, will be intensified. Mr. Deputy Speaker, sir, collaboration between these 2 schools will be reinforced through joint activities and discussions with the stakeholders, including the Child Development Unit and the Crime Prevention Unit, who will conduct awareness sessions on the legal consequences of vandalism and violent behavior. Regular workshops on conflict resolution, empathy building, and peer mediation will further strengthen positive student engagement. Mr. Deputy Speaker, sir, I also take this opportunity to clarify that my ministry has already taken a firm policy decision regarding Terre Rouge SSS. The school is being progressively phased out and will become an exclusively girls' school. The intake of boys has already ceased, and this transition is ongoing. In the spirit of good neighborhood relationships, I will personally ensure that a meeting is convened shortly to consolidate ties of friendship between these 2 neighboring institutions. The students will be sensitized to view this proximity as an opportunity for enrichment rather than conflict. They will be encouraged to leverage shared infrastructure, promote a culture of respect, and foster a sense of belonging. These schools exist not to be divided by hostility, but to thrive through collaboration and mutual growth. In the future, many joint projects can be developed to transform this shared space into a model of cooperation and unity. Thank you.
The Honourable Second Member for Savan and Laconia.
Mr. the Deputy Speaker, sir, B159.
Thank you. I am informed that the plot of land situated at Martiniere Road, Suriname, was initially vested under the Ministry of Local Government on 14 December 1988 and subsequently allocated to the then District Council of Grand Port-Savan for the purpose of operating a waste disposal site. Mr. Deputy Speaker, sir, following the commissioning of the Morshico sanitary landfill in 1997, the dumping site at Morshico's Martiniere Road was officially closed. Since then, it has been utilized solely as a temporary dump site for the collection and removal of post-cyclonic green waste. This arrangement was made with the agreement of the Solid Waste Management Division of the Ministry of Environment, Solid Waste Management and Climate Change, which is responsible for transporting post-cyclonic waste from the temporary site to the landfill. In accordance with Section 59 of the Local Government Act 2011, as subsequently amended, first, the Permanent Secretary is mandated to formulate policies and strategies. And second, waste minimization and resource recovery. And B, storage, collection, conveyance, and disposal of waste. Second, the Permanent Secretary, in compliance with regulations established by the Minister, is responsible for A, the operation and management of disposal sites and waste management facilities, and B, control of private operators in the field of waste management sector. Mr. Deputy Speaker, sir, the Local Government Act 2011, as subsequently amended, outlines in Section 60 the responsibilities of local authorities with respect to waste management. Specifically, local authorities are required to, first, implement programs and establish mechanisms for waste minimization, storage, collection, and conveyance to designated waste disposal sites or waste management facilities. And second, ensure that waste is placed in appropriate storage receptacle for collection. And third, arrange for regular collection of waste within their jurisdiction and its transfer to disposal sites or waste management facilities as necessary. Following the reallocation of ministerial portfolio after the general election of 2014, the responsibility of solid waste management now falls under the Ministry of Environment, Solid Waste Management and Climate Change. Consequently, it is the responsibility of the Ministry to develop and implement the necessary regulations for the effective operation and management of waste disposal sites in accordance with national policies and environmental standards. Mr. Deputy Speaker, sir, it is important to highlight that on 13 November 2024, an annual cyclone preparedness meeting was convened at the Solid Waste Management Division of the Ministry of Environment, Solid Waste Management and Climate Change. The meeting was chaired by the Director of the Solid Waste Management Division and was attended by representatives from my ministry, local authorities and contractors appointed by the Solid Waste Management Division. The discussion focused on the following key issues. First, the use of former dump sites for the reception and temporary storage of cyclonic waste following cyclonic events. Second, the identification of new sites for temporary disposal of cyclonic waste. And third, the revision and updating of contingency plans for the management of cyclonic waste. During the meeting, each local authority provided update on their respective temporary dump sites. The District Council of Savan, in particular, reported that a plot of land at Martinia Road had been identified as its temporary dump site. It was further agreed that this site would be utilized for the disposal of cyclonic waste in the event of a cyclone, where a substantial amount of green waste would likely be generated following its passage. Mr. Deputy Speaker, sir, the chairperson has instructed that contractors of the transfer stations must accept normal waste, whereas green waste is to be directed to temporary dump sites. At these sites, contractors are responsible for cutting, sorting, and processing the green waste before transporting it to their respective transfer station. I have been informed that following the fire outbreak at the Marshy Coast landfill on 10 December 2024, the scavenging lorries of the District Council of Savan were denied access to the landfill. Consequently, with the agreement of the Solid Waste Management Division, household waste was temporarily deposited at Martinia Road to ensure continuity of waste disposal service. Upon the reopening of Morshico's landfill, all waste at Martiniere Road was completely removed. Furthermore, no dumping signs were installed at the site, and access to Martiniere Road has been permanently restricted with boulders to prevent unauthorized dumping. Mr. Deputy Speaker, sir, unlike the previous administration, this government is committed to action. We are deeply invested in environmental protection and are dedicated to implementing concrete measures to uphold this commitment. The Council has decided to, henceforth, the site will be properly fenced to ensure effective management and environmental compliance. Additionally, there are plans to develop a plant nursery and a composting facility on part of the land at Martiniere Road, while the remaining area will continue to serve as a temporary dump site for the disposal of post-cyclonic waste. And the total cost of the project is estimated at approximately 30 million rupees, and the provisions for its execution will be included in the next financial proposal budget.
The Honourable Third Member for Parti Democrat.
Thank you, Mr. Deputy Speaker, sir. B160.
Mr. Deputy Speaker, sir, I am informed by the National Land Transport Authority, NLTA for short, that there are currently 6 vacancies at the administrative and management level of the NLTA, namely in the post of Deputy Road Transport Commissioner, Transport Planner, Transport Controller, Chief Vehicle Examiner, and Administrative Manager. As regards the Inspectorate and Enforcement Department of the regulator, I am apprised of some 40 vacancies spread over the posts of Chief Road Transport Inspector, Principal Road Transport Inspector, Senior Road Transport Inspector, Road Transport Inspector, and Traffic Warden, including some 30 vacancies at the level of the Road Transport Inspector per se. I wish to highlight that while some of the vacancies at the management level date back to 2019, those in the Inspectorate cadre have occurred since 2023. The situation, Mr. Deputy Speaker, sir, undoubtedly showcases a lack of succession planning at the NLTA. The absence of senior officers at administrative and management level impact significantly on the overall operation of the department, entailing delays in the processing of applications, attending to public complaints and grievances, and solving the problems of customers calling daily at the NLTA office. We've seen many articles and outcry from among the public in respect to this state of affairs. The state of affairs resulting in the lack of inspectors is even more severe and is reflected every day in the numerous complaints received from the travelling public in respect of the poor level of service being provided by bus operators along most of the routes throughout the island. My colleagues in the House would know what I'm talking about. The bus operators are taking advantage of the absence of inspectors to either not observe their established timetable of operation or even not to operate their buses while claiming the full amount of their fee travel compensation and other subsidies, which I remind the House amount to some 2.5 billion rupees per year. With regard to Part B of the question, Mr. Deputy Speaker, sir, I'm informed that all vacancies have already been reported to the Public Service Commission, and same will be filled as and when decided by the latter, and subject to funds being made available as well. Moreover, what is more surprising is that since 2023, nothing has been done in respect of the post of road transport inspectors. I am informed it is only after the dissolution of Parliament on 4th October 2024 that applicants were called for interview by the then Commission, which is outright against the principle of good governance, and unfortunately the recruitment exercise will have to be conducted afresh for obvious reason, therefore entailing further delay in the process, notwithstanding the fact that these road transport inspectors are much needed to redress the state of affairs of the regulator and to assist in the improvement of the pool level of bus transport services across the island, like I mentioned earlier. Now, nevertheless, my ministry will ensure close follow-up for the filling of the aforementioned vacancies within the best possible delay. Mr. Deputy Speaker, sir, I wish to put on record that since I took office at the ministry, I have had several meetings regarding the shortage of staff at the NLTA, and the latter has been urged to come up with concrete measures with a view to facilitating the recruitment process while ensuring the right person at the right place. I wish to reiterate to the House that my ministry has already initiated procedures to enlist management support officers to strengthen the NLTA inspectorate pending the recruitment of substantive staff. This is not quite a given because MSOs are supposed to work in office, but now we are deploying them onto the site. So there is a process to follow to get the approval for this. These MSOs will be daily deployed on bus stations and along bus routes to ensure NLTA presence and compliance with a schedule of bus services. Thank you.
The Honourable third member for Parlementaires.
Deputy Speaker, sir, B161.
Thank you very much. Mr. Deputy Speaker, sir, with regard to part A of the question, I'm informed that the number of fishermen cards allocated to the aforementioned regions for the past 3 years, that is from 2022 to 2024, are as follows. Bézitombe 64, Pointe-au-Piment 6, Drobiche 34, Grand B 30. As regards Monsoirgie, I understand that the Honourable Member is referring to Pointe-au-Calbenier Fish Landing Station. I'm informed that 2 fishermen cards have been issued for that region in the year 2022. Mr. Deputy Speaker, with regard to part B of the question, I've been apprised that for the 5 sites under reference, 2 persons have been booked and contravened for illegal fishing from 2022 to 2024. Moreover, 4 persons have been booked and contravened for period January to February 2025 for illegal fishing at those sites. Regarding the last part of the question, any unlicensed fisherman who wishes to regularize his or her situation should submit an application for fisher's card. In case an applicant fisher fulfills the set criteria, we circulated this criteria when the question was put to me some time back. Now he will be granted a fisher card.
Another question?
Mr. Deputy Speaker, sir, is the Minister aware that there is a yearning demand of many unlicensed fishermen who go to fish and catch for us on a daily basis and to earn for their families, but they still haven't been considered for a license? Will his ministry consider to allocate proper licenses to these fishermen in the near future?
The Honourable Member should be aware that none of us is insensitive to the plight of a fisher. There are some who unfortunately do not have a fisher card, and therefore they're involved in what we would call illegal fishing activities. But certainly we will entertain as and when required, because we cannot have far too many fishers, because we have to think of also the stock that is in our lagoon. But certainly we'll give due consideration.
With regard to the Pointe-au-Piment and Monsoirgie? Pointe-au-Piment and Monsoirgie.
As the Minister aware that these cards has been delivered at the eve of the last general election without any control and good vetting, will the Minister ensure the House that the future cards that will be delivered will have a better vetting, and also after issuing this card, if regular verification will be done to ensure that the real fishermen are having their cards? Thank you.
This exercise has been carried out But of course, as a responsible government, we are not going to disrupt the system violently. Those who are deserving cases, certainly those cases will be entertained, but in relation to those who have obtained Fisher's card against, set criteria, certainly appropriate action will be taken.
The Honourable Third Member for Bobassa-Bichitevia.
B162.
Mr. Deputy Speaker, sir, I wish to thank the Honourable Member for this question, which provides me with an opportunity to enlighten the House on this programme that was launched under the previous government and which contains many weaknesses. I'm informed that further to the adoption of the National Sports and Physical Activity Policy 2018-2028 in October 2018, the Mauritius Sport Council had developed an active Mauritius strategy that was launched in July 2019. The active Mauritius strategy is aligned with the philosophy of the policy and advocates for the widespread practice of sport as a means to achieve the policy's objective. Mr. Deputy Speaker, I'm informed that 14 programs that are run by the Mauritius Sport Council under the active Mauritius strategy are categorized accordingly to the following target audience. First, Move It, for those aged from 7 to 13 years old. Second, Youth on the Move, for those aged 14 and 24 years old. Third, Aging Well, for those aged 25 to 65 years old. And fourth, Elderly Fitness, for those aged above 65 years old. Mr. Deputy Speaker, as regards to part A of the question, I'm informed by the Mauritius Sport Council that the amount of funds allocated in favour of active Mauritius on yearly basis is as follows. For financial year 2018 and 19, 38 million rupees. For financial year 2019-20, 35 million rupees. For financial year 2020-21, 36 million rupees. For financial year 2021-22, 47 million rupees. For financial year 222-223, 47 million rupees. For financial year 23-24, 65 million rupees. For financial year 2024-25, 64 million rupees. In view of the substantial amounts allocated to the Mauritius Sport Council over the past years, I have some serious concern about the running of these programs. I have already instructed the new board to carry out an evaluation, therefore, and my permanent secretary to cause a full-scale inquiry to be carried out. Mr. Deputy Speaker, sir, as regards part B of the question, I'm informed by the Mauritius Sport Council that the coaches who deliver the programs of Active Mauritius are not employed on a region-wise basis. The number of coaches employed, the detail of their respective discipline and allowances are being compiled by the Mauritius Sport Council. Once available, same will be placed in the library of the National Assembly.
Des Sports, dans sa réponse, a fait état des faiblesses par rapport à ce programme. Peut-il effectivement nous dire quelles sont les faiblesses qu'il a constatées depuis sa prise de fonction par rapport à Active Mauritius?
All information are being compiled and I will lay in the National Assembly all the details about what we have witnesses and what we are still being witnesses in these manquements.
Même si je ne suis pas très satisfait de la réponse du ministre. Je ne vais pas aller plus loin par rapport à cette question supplémentaire. J'aimerais savoir, vu que ce programme Native Mauritius est un projet du gouvernement sortant, est-ce que l'honorable ministre compte continuer dans sa forme actuelle ou bien il compte apporter des changements de façon à ce qu'on puisse satisfaire les sportifs et toute la population en général?
Certainement, nous allons revoir le tout dans son ensemble.
The first member for Savannah and
Thank you,
Blackburn.
Mr. Deputy Speaker, sir. B163.
Mr. Deputy Speaker, sir. The villages of Tamarin, La Preneuse, and Black River are connected through the Black River A3 road. The western region, including these villages, is witnessing increasing urban development, and as a result, the A3 road, in its present configuration, is quite limited to cope with the rising demands of vehicular and pedestrian traffic. In this context, the Road Development Authority has enlisted the services of a consultant, namely Lux Consult, Mauritius Limited, to work out the preliminary design of the proposed Tamarin bypass, which will extend over approximately 8.5 kilometers, providing an alternate route between Yemen and Grande Rivière Noire. The main aim of the project is to, inter alia, reduce traffic congestion and travel time along Rivière Noire Road A3, as well as enhance accessibility by providing an alternative route from Tamarin via Yemen towards Grande Rivière Noire on A3 road and vice versa. But, Mr. Deputy Speaker, sir, I'm informed by the RDA that the consultant has already submitted the following reports in respect of the project. First, an inception report. Second, a traffic impact assessment report. And third, a draft environmental impact assessment report. It should be highlighted that the proposed project is quite complex and is characterized by several constraints, mostly associated with the hill at Yemen La Coupé and river crossings along the proposed alignment. To address these issues, appropriate geotechnical and environmental investigations are currently underway, and same, together with the final preliminary design report, are expected to be completed by May 2025. Upon completion of the preliminary design, the RDA will take into consideration the recommendation of the consultant as well as cost implications, and will accordingly recommend a timeline for the implementation of the project.
The Honourable Fourth Member for Holding.
Mr. Deputy Speaker, sir, B164.
Mr. Deputy Speaker, sir, in the context of our strategy to have an inclusive and value-based education while reckoning the specificity of Rodrigues, my ministry is giving due consideration to promote the Rodrigan values and culture. In fact, in the primary school textbooks of history and geography, Creole Mauritian, English and French of different grades, several topics on Rodrigues are covered. Moreover, my ministry has already taken steps to ensure cultural relevance in the curriculum, such as 1. The teaching of Creole Rodrigues in primary schools in Rodrigues since 2020. 2. The inclusion of Rodrigan stories and contexts in English, French, and Creole Rodrigues curricula. And 3. The coverage of Rodrigan history and geography in the respective curriculum. Mr. Deputy Speaker, sir, moreover, as the House is aware, my ministry will hold the Assises de l'Éducation in April 25, wherein the representatives of the Rodrigues Regional Assembly will also be invited to participate. As Honourable François, second member for Rodrigues, has informed the House on 4th March 2025, Rodrigues is seeking an educational reform and model that align and adapt with its socio-economic realities. All the proposals of the stakeholders, including Rodrigues, will be taken on board, and the outcome of the Assises de l'Éducation will pave the way forward for a review of the present educational system and the formulation of new policy direction as from the year 2026, including the review of the curriculum. Mr. Deputy Speaker, sir, I will soon set up the National Curriculum Advisory Board, which will inter alia advise my ministry on a national policy for the development of the school curriculum with regard to the overall economic, social, and cultural context of the country, including Rodrigues. Besides, Mr. Deputy Speaker, sir, my ministry will also set up the National Education Council in order to inter alia review the implementation of plans, policies, strategies, programs, and projects for the provision of education in Rodrigues. A representative from the Rodrigues and Outer Islands Division will also be nominated on the Council in order to take on board the proposals of the stakeholders in Rodrigues. Mr. Deputy Speaker, sir, I wish to reassure the House that we envision to further integrate elements of Rodrigan history, culture, tradition, and values in the school curriculum in Rodrigues. We would welcome any proposal from the Rodrigues Regional Assembly in this regard, such as the revisited curriculum meets the needs and aspirations of the people of Rodrigues. Thank you.
The Honourable, you got a question?
If you will allow me, excuse me for my voice, Mr. Deputy Speaker, sir. With the coming assizes, may I ask the Honourable Minister whether participative approach consultations have been or will be held with all stakeholders in Rodrigues, not only the Regional Assembly, with all stakeholders in Rodrigues? If so, when?
Mr. Deputy Speaker, sir, it is being planned that prior to les Assises in Mauritius, which will be held on 15th, 16th, and 17th of April, a delegation from the Ministry of Education will go to Rodrigues and sit down with those involved in that, listen to them, so that that participation, that input is discussed during les Assises de l'Éducation.
Okay, the first member for holding.
Mr. Deputy Speaker, sir, question B165, please.
Mr. Deputy Speaker, sir, with regards to part A of the question, I wish to draw the attention of the House that as per section 4 of the Legal Aid and Legal Assistance Act, for a person to be eligible for legal aid in regards to civil or criminal proceedings, including a bail application or an appeal to the Supreme Court, he must not be worth more than 500,000 rupees, excluding his wearing apparel and tools of trade, and his total monthly earnings shall be less than 15,000 rupees. The same eligibility criteria apply to a detainee or an accused party, where the latter seeks legal assistance during a police inquiry or for bail applications. These ceilings were last looked at in the year 2018 and have not been reviewed, notwithstanding the increases to pensions and the basic wage over the last few years. In addition, at district court level in criminal matters, legal aid is only available for a limited list of offences. Mr. Deputy Speaker, sir, amendments will be brought in the coming weeks, sooner than later, to the Act, as already alluded to during my address to the House on the 2025-2029 programme. The amendments will focus on a rise of the ceilings so that these are more in line with what obtains in terms of revenue and ownership today, with particular attention to the accessibility of the service for citizens from economically disadvantaged backgrounds and vulnerable groups. Mr. Deputy Speaker, sir, with regards to Part B of the question, I wish to inform the House that as the law currently stands, a person has to make an application to the court to obtain legal aid or legal assistance. What is, however, clear is that many citizens are not aware that they may be eligible to obtain legal aid or legal assistance in certain cases, civil or criminal. Indeed, the Act as it stands today lists in a schedule the various sections of the criminal law which would find application without actually saying what offences they relate to. So even if one reads the Act, it gives no adequate and proper indication to the citizen. To render justice accessible, this will have to be tackled by an appropriate amendment, so that a citizen would be able to see for himself for which offences he may apply for legal aid. There are also a number of offences which should have been listed in the Act, but which are not. We will review this too. Finally, and that is the end of my answer, Mr. Speaker, sir, in the same vein, we will also bring amendments to the Act so that the court will have a duty to inform a person when he is not represented by a legal practitioner that he may apply to obtain legal aid and legal assistance in cases where the law provides that legal aid is available, of course, if that citizen satisfies the relevant criteria.
The Honourable Second Member for Rivière-des-Anguilles, Souillac.
Question B166, please.
Mr. Deputy Speaker, sir, at the outset, I make no apology for what will be a long reply to that question by the second member for Rivière-des-Anguilles and Souillac. Mr. Deputy Speaker, sir, allow me please first to say that this case is a prime example of how the rule of law could be subverted and weakened by government for want of proper legal guidance, of how our courts of justice were considered not so long ago, last year, as an inconvenience that could be bypassed by the powers that be. Mr. Deputy Speaker, sir, I will first briefly clarify the circumstances under which this foreign national came to Mauritius, resided here, and was later forcibly removed. This Slovak national came to Mauritius in February 2019 from Kenya on a tourist visa. On 13th of March 2019, less than a month later, he applied through the EDB for an occupation permit. A month later, it appears that searches made on the controversial list of the Passport and Immigration Office, the Interpol database and WorldCheck returned no results for him. His application for an occupation permit was thus approved for a period of 3 years. So much for proper due diligence. On 5th November 2020, the Attorney General's Office received a request from the Slovak Republic for the arrest and extradition of that foreign national. He was wanted for prosecution in his country for having at the time allegedly masterminded from 2015 to 2018 a criminal group providing ingredients to produce dangerous drugs to the tune of 16 million euros. In January 2021, the Attorney General's Office wrote to the appropriate authorities in Mauritius to confirm the presence of the foreign national in our country. And having received confirmation, we prepared draft applications for his arrest and extradition. However, these applications were kept in abeyance due to the second COVID-19 lockdown. Upon the reopening of the Mauritian borders in October 2021, the Attorney General's Office inquired whether the Slovakian authorities were ready and willing to remove that foreign national from Mauritius should an extradition order be made against him. On 15 February 2022, the Attorney General's Office received confirmation from the Slovak authorities, and the applications for the arrest and extradition of the Slovak national were consequently lodged on 22nd of February 2022 before the District Court of Port Louis. He was arrested on the same day and was bailed out on the 9th of March 2022. In the same month, the Slovak national applied for a renewal of his permit as well for a clearance certificate in order to marry a Mauritian national. However, on the 15th of April 2022, the then Prime Minister deprived that foreign national of his status of resident in exercise of his discretion under Section 6 of the Immigration Act, after being satisfied that it was in the public interest to do so. Notice of this change in his status, although decided on the 15th of April 2022, was only served on the foreign national at his last known address on 22nd of April 2022. Mr. Deputy Speaker, sir, up to this point, clearly we had due process. We had a person who had entered the country legally, became the object of extradition proceedings at the instance of his home country, and who, whilst these proceedings were still underway, also became a prohibited immigrant. From there on, there were two ways that this foreign national could be removed from Mauritius legally. Either the court in the extradition proceedings reached the decision that it was to send him back to Slovakia for prosecution, or as a prohibited immigrant, he could be subject to a deportation order under that act. But this was possible only after the procedure under Section 5 of the Deportation Act was followed, which involved allowing that foreign national the opportunity to show cause why such an order ought not to be granted. Here we have to point out, I have to point out, that there is a deficiency in the deportation process, in that the deportation order to be made by a minister, here the Prime Minister, under Section 4, has to be in a prescribed form. And funnily enough, as at now, no such form has been prescribed. This is a lacuna that this government intends to address very soon. Irrespective, Mr. Deputy Speaker, sir, I have to inform the House that on 26th of April 2022, an order in the form of an interim injunction issued by a judge of the Supreme Court was served on the State of Mauritius, the Prime Minister's Office, the Passport and Immigration Office, the Attorney General's Office, and the Director of Civil Aviation, prohibiting and restraining them from either deporting or extraditing the foreign national. In spite of this, I am informed that on the very same day that the injunction was granted, the foreign national was arrested anew, purportedly on the basis of the Immigration Act, conveyed by the police to the Sir Siusagar Ramgoolam International Airport for his forcible removal by Slovakian authorities, which had been dispatched by a special flight with his own law enforcement officers, ready to take custody of their foreign national on our soil. The flight took off just before 4 p.m. at a time when the state, the PMO, the PIO had already been served with the court order. The justifications for this course of action were given to this House by the then Prime Minister on the 10th of May 2022 in his replies to PQ 525 and 530, and in a communiqué by the Prime Minister's Office dated 30th of April 2022, and as well as on many public occasions by the former Attorney General. I will summarise them as follows. One, they said, the Immigration Act allegedly provides for a route distinct and independent from the Deportation Act or the Extradition Act, allowing for the arrest of the foreign national and his conveyance to the Slovakian agents to forcibly take him away. Two, they said, since the procedure followed was neither that of a deportation or extradition, the court order was not flouted, because those were the only routes which had been stated in the court order, deportation or extradition, and neither were used, they said. Third, they said, in any event, the police was not subject to the court order. You remember, it was PMO, PIO, Civil Aviation, and Attorney General. And we all know who the Attorney General represents. In any event, they said that foreign national was a dangerous criminal that had to be removed, but who had been granted an occupation permit within 60 days of his arrival as a tourist in Mauritius. Mr. Deputy Speaker, sir, their reasoning is alarming. Let me dispatch the first reason they put forward by stating that nowhere in the Immigration Act, as it stood in 2022, is there power to deport someone who had been residing, albeit illegally, in Mauritius. There are provisions to declare one, a prohibited immigrant, and there are provisions to lawfully detain persons seeking admission to the country. Section 20, invoked by the previous government, does not create any new standalone power to arrest or detain an illegal resident. Those powers fall squarely under the Deportation Act. Mr. Deputy Speaker, sir, this is legal interpretation, and this is clearly not the place to debate it. I will readily concede that a legal question may have as many answers as there are lawyers to answer it. However, even a mistaken reading of the Immigration Act could not justify the rest of the previous government's reasoning. I stand advised that there is an action for contempt regarding this case presently before the Supreme Court awaiting judgment. I shall therefore not say more. This new concept of removal, quote unquote, which involves placing the person in question in the hands of foreign agents on our soil, is devoid, in my humble view, of any legal substratum. No explanations was ever given as to the legal basis for Slovakian agents to use legitimate force on our national soil in order to take away their national. No explanation was given, Mr. Deputy Speaker, sir, because there is none. Because, as the Prime Minister's office itself stated in its communiqué, this was not done under either the Extradition or the Deportation Act. There is, in fact, a name for this, Mr. Deputy Speaker, sir, a name often used in human rights discussions around the world. This was a disguised extradition, whereby a wanted fugitive is handed over to a foreign state by means other than the classical extradition, bypassing the usual safeguards of the law and the scrutiny of the courts. Mr. Deputy Speaker, sir, the most extraordinary part of the previous government's justification is this insolent insistence on the fact that, I quote, "At no material time was the police the object of a court order. It cannot be disputed that the Commissioner of Police is but an agent of the state, and an order against the state necessarily implies that its agent must comply with that order. It would be inappropriate, of course, at this juncture to opine on the consequences of what happened, and this would fall squarely in the realm of the court proceedings awaiting judgment, as I alluded to earlier. Mr. Deputy Speaker, sir, it does not matter if that foreign national was later sentenced in Slovakia to 22 years of imprisonment for the illicit production, possession and trafficking of drugs. Of course, such persons are not welcome in Mauritius. They should never have been granted an occupation permit in the first place. But the only way we will truly tackle the drug trafficking, illegal immigration or any other crime is by making sure, first and foremost, that everyone respects the law, including the state. That is the rule of law, or else our grand speeches in this august assembly would not mean a thing. Here we are left to wonder how this person was granted his occupation permit in such short a period of time by the authorities. We are equally baffled by the alacrity shown by the authorities to dispatch that person out of the country. Is there a correlation? I wonder. That being said, this is the rule of law which we want to restore, Mr. Deputy Speaker, sir, and this is how I will therefore answer the second part of the question of the honourable member. There is no other way in order to avoid such occurrence in the future than to learn from the mistakes and flaws of our predecessors, and for me and members of my office to adhere strictly to the rule of law, irrespective of the cost that it entails. Thank you, Mr. Speaker.
Thank you. The table has been advised that the following PQs have been withdrawn. B187, B191, B194, B190, B195, B176, B170, B174, B179, B183, B182, B184, B168, B188, B180, B193, B175, B186, B181, B177, B167, B171. Time is over for question time. Madam Speaker, we resume the chair.
Please be seated.
Motion.
Madam Speaker, I beg to move that all the business on today's order paper be exempted from the provisions of paragraph 2, Standing Order 10.
The question is that all the business on today's paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye, those against say no. Ayes have it. The motion was seconded by the Deputy Prime Minister.
Statement by Ministers. None. Public Bills, first reading.
Madam Speaker, I beg to move that the Representation of the People Amendment Bill number 4 of 2025 be read the first time.
The motion needs to be seconded. Again, Deputy Prime Minister.
Public Bills, second reading.
Yes, Honourable Prime Minister. Floor is yours.
Those are mine, and I seem to have left my bill in there, but never mind, I can speak.
Happens to all of us.
Yes. I beg to move that the Representation of the People Amendment Bill number 4 of 2025 be read a second time.
Thank you. The motion needs to be seconded. Seconded. Yes. Okay.
Madam Speaker, for this bill, as it explains in the explanatory memorandum, clearly is to amend the Representation of the People Act so as to provide the compilation of a new supplementary register of electors for the forthcoming municipal and municipal town council elections, or for such other election that may be prescribed. And this will be compiled immediately after the writ of elections, thus allowing qualified, unregistered persons to submit their claims to be registered and have their names included in that supplementary register of electors. This is being done, Madam Speaker, so that every elector has a right to vote until when the elections are called. Madame la Présidente, pendant la campagne électorale, nous avions dit et redit que nous allons approfondir la démocratie à Maurice. One of the ways that we've canvassed before with the Electoral Commissioner and the Electoral Commission, that very often, this is a problem. A lot of people turn out to vote for an election. Their name is not on the register. There are many reasons for this. First of all, the canvasser who goes around to register electors, he might press the door button, nobody answers. He's supposed to come back. I am told that very often they say, maybe he came back, nobody was there, or else he never came back. These people think because they voted in the last election, the name will be on the register. We do a lot of advertising in our party, at least, that they should go and check their names. They don't very often. But the result that the names aren't there. And they turn up to vote, they are told that the names is not on the register. There can be nothing so frustrating as you wait for 5 years to go and vote, and then you don't find your name on the register, you're told you're not going to vote. In the last general elections, in the last, I think, municipal elections, there were some 1,900 something of electors who did not manage to vote. Officially, this is the number. But unofficially, I'm sure it is higher, because many people, when they're told they cannot vote, they protest, but they do not protest officially, they go home. So the numbers are not counted in that number. So we end up with this situation where people are not able to vote. Secondly, I think it is absurd that the register is compiled on the it closes on the 15th of August of whatever year. A person who is born on the 16th of August of that very year cannot vote until the register is recompiled the following year. So that person has turned 18 but cannot vote. This is what the situation was until now. What we are doing, Madam Speaker, is to correct an injustice. You know, Professor Albi Sachs, who came and reported on the electoral system, had this to say, I'm quoting offhand, he said that it is unbelievable that a person who is born on the 16th of August cannot vote in any election until the following year, that is after the 15th of August, before the 15th of the following year. That is completely unacceptable. This is what we are correcting here. We are saying that this supplementary registration will be done, but it doesn't mean that somebody who has already been registered as elector can go on the supplementary list. That is a separate list for people who have turned 18 after the 15th of August, who are not on the list at the moment, who will be able to go on the list. They will have until 5 days after the writ of the election is issued, 5 days for them to go and ensure that the name is on the list. It is correcting a major injustice that was happening in our system. You have many people who have said that there's a book called How to Rig an Election by Cheeseman and somebody else. And they go on about this. Suppression of voters from a list is one of the ways to commit fraud in an election. This happens in many countries even today. Even in America, they're complaining that there has been suppression of voters. So it's not just Mauritius. What we are trying to do is to ensure that people get a chance, if they want to vote, to go and put themselves, register and be on the list of electors. I must also add, Madam Speaker, this also applies to somebody who wants to stand in a municipal election. If you're not on the register, you cannot be a candidate in an election. So this will also correct this injustice. Especially a young person just turned 18, maybe wants to stand as a municipal councillor. He would not have been able to do so unless he was already on the list, which was closed on the 15th of August of last year. This is what we are correcting, Madam Speaker. The second thing we are also doing, we didn't say this in the bill, but we are also ensuring that the counting is done on the same day. Some people think that we will need to amend the law again. We don't have to. This is done by regulations. Madam Speaker, in Nigeria, I think there are 23 million people. They count on the same day. In Kenya, I can't remember the exact figure, it's over 40 million. Counting is done on the same day, over 50 million. In the UK, it's over around 43 million. Why can't we in Mauritius have counting on the same day? This has the advantage. I understand we did canvass this with the Electoral Commissioner and the Electoral Supervisory Commission as well. There are logistical problems. They have genuine logistical problems. But we must overcome that problem. We are overcoming it now. We do not, in the past, there were not enough staff to start with. They were probably not even paid properly. That's another problem. But we will look into all this to make sure that counting is done on the same day. Because if when you don't count on the same day, this business of carrying boxes, ballot boxes, in all sorts of lorries, in the last, not this, in the preceding general election, 2019, in my own constituency, we have witnesses, boxes were carried in garbage trucks, in CWA lorries, with people we don't know. Our agent, the Electoral Commission, has said it and said it over again, that our agent has a right to go in the lorry. But on the day of the election, we get a policeman who's probably very pro-government, says, no, you can't get in the lorry. Who is going to go now and challenge him or ask the Electoral Commission to come and see what's happening? This has happened in many places. In number 10, in many villages, this has happened. This idea of carrying boxes and then storing them in a place, it's fraught with possibilities. What we are doing is closing the loopholes. It is a loophole. In other countries, ballot boxes were changed. In the country, I'm told they had double floors. And during transporting, they were changing I don't think this happened in Mauritius, but I can't say. For sure, I can't say. Because we're not even allowed to look into the lorries. We're supposed to be allowed, but we were not allowed. In one of the lorries, when in the 2019 election, I asked somebody, what are you doing there? He didn't answer me. I kept asking him, he didn't answer me. You know why? He was a foreigner, not a Mauritian. He's there in the lorry, standing in the lorry, sitting in the lorry, and he was in the lorry to carry out this business of carrying boxes. That is something we're also closing. Counting on the same day is possible, must be possible. Of course, the ESC will need manpower, but we'll have to ensure that this is so, and therefore this is what's going to be a thing of the past. And we want to be able to do this for general elections as well. The third point that was canvassed by the Electoral Commission and the ESC, which we totally agree with, that we should look at the possibility of Mauritians who are abroad to be able to vote in an election. In other words, the diaspora. Today, people from other countries are voting in Mauritius. And yet, Mauritians who are abroad cannot vote for their own country. That is something that we also intend to look at very positively and probably will happen. These are the three main things that I wanted to say on this, Madam Speaker. We've seen, apart from the fact that this is a great leap forward for the youth of this country. My party gave the right to vote to young people at the age of 18. Today, this alliance is allowing people who have just turned 18, who are not on the register, to be able to vote. This is one of the major reforms that we're doing for the electoral reform. This is one of the reforms. We're going to have other reforms as well. Secondly, we're going to have counting on the same day, as I said. Madam Speaker, denying a person of his right to vote, I can't see anything more treacherous and unjust. How can we allow somebody who waits for 5 years to boot out a government, as they did in the last election, and yet not able to vote in that election. There has cases that happen. Sorry? 10 years. Thank you for reminding me. The previous government, they postponed elections, not once, not twice, 3 times, Madam Speaker. For 10 years, people have not been allowed to vote for the councillors. Shame. It's a great shame. Find all sorts of excuses, as you say, all sorts of excuses. We're going to have it. We had agreed. The Deputy Prime Minister, when we were passing the law about not allowing postponement of the village elections, he mentioned, he was leader of the opposition, he mentioned it at the time, that we should do it for all elections, general elections as well. We will do it this time. We have to do it. We have to do it. Same thing, I forgot my speech in my office. And, but I think I've said what I've said. This is the first step, what I said. I said it better. As you say, we should be reading our speeches.
No, you've done very well up to
So
now.
far. The Representation of the People Act, which is the main piece of legislation governing our electoral process, was enacted back in 1958, at a time when Mauritius was still a British colony. 1958. And that in England, they have modified that law, but not in Mauritius. The law has stayed, just some modifications, has stayed the same. We just celebrated the 57th anniversary of our independence. And yet, a law that was passed in 1950, that is 67 years ago, it still applies for registration of electors. We know, Madam Speaker, that the right to vote is enshrined in our Constitution. Section 44 of the Constitution provides that every citizen shall be entitled to vote if he or she is registered as an elector in this constituency. The first step in a democracy is to make sure that people can vote. Those who are registered should be able to vote. And, Madam Speaker, the other problem, I've already said all this, I'm not going to go through all this, but in this case, the town council for municipalities have already been dissolved. I think it should have been dissolved yesterday. Yeah. So we're going to have the writ, and they will have 5 days after the writ to be able to register again. I remember, if I could, Albie Sachs, the proper quoting, he said, the disadvantage of the present system is that if elections are held after the 16th of August, which I just said, that person cannot vote until he's re-registered on the 15th of August of the following year. Further, he does also say that this house-to-house inquiry depends on the canvasser necessarily reaches the home where the people are there. Madam Speaker, we find it unacceptable that it is an assault on democracy to deny anybody his or her right to vote. With this bill, as I said, we're correcting this injustice. Voting is a civic duty. We should not deprive any citizen of his right or her right to vote. Madam Speaker, I want to quote somebody else, John Lewis, who is a civil rights, who was a civil rights man, he's passed away. He said, the vote is precious. It is the most powerful, non-violent tool that we have in a democratic society, and we must be able to use it. As a responsible government, this is exactly what we are doing. Now, Part 2A of the Act, which provides for the compilation of the supplementary register, is also, it will be an addendum to the main register. As I said, people who are already on the main register will not be allowed to go on that other register. The other thing is whose person, if he's already, as I said, on the register, will not. But the other thing that I need to say is that after the Electoral Commissioner, I must say, was also of the view that the introduction of a supplementary register directly addresses the key issue of voter suppression. It ensures that eligible citizens who were not on the list are able to go on the list. The Supervisory Commission also consulted, was welcome this what we're doing, this move what we're doing. And I must also say, Madam Speaker, that this bill also contains adequate safeguards to prevent fraudulent or erroneous registrations. Provision is made under the new section 39F of the bill for objections to be raised against entries in the supplementary register. The procedure for raising an objection is clearly outlined in the bill, and they can, if somebody is not satisfied, can go to a judge in chambers to get redress if he thinks or she thinks there has been some fraud. It would also be additionally making it an offense to make false statements. It's already an offense, but we are making it punishable by fine not exceeding 10,000 rupees and a term of imprisonment not exceeding 1 year. Madam Speaker, different democracies in the world have different practices concerning registration. In the States, United States, they allow qualified citizens to register and cast their vote on the day of the election itself. I don't know how they managed to do this. Maybe the Electoral Commissioner could tell us, because it's not an easy task to be able to register on the day, because it has loopholes. Others have a continuous voter registration. Australia closes its electoral roll 7 days after an election is called. But the success of any electoral reform depends also on the local specificities to be taken into account. We all know, we all agree that democracy should be inclusive. The fundamental principle that every eligible citizen should have an equal opportunity to vote. With the dissolution of the municipal city council and municipal town council yesterday, we now move to the upcoming municipal elections, where the supplementary register will play a crucial role. We should not allow a democratic process to be hindered for administrative reasons or outdated systems. But by extending the voter registration period, we are reaffirming our commitment to a more inclusive and representative democracy, one that truly reflects the voices of all the people. Madam Speaker, I should also say, some people might ask, but why this idea of keeping the boxes overnight? This is the reason being, a long time ago, there was no electricity in the villages. They had to keep, they couldn't, they wanted to, not to count with the candles, because counting with candles, you never know, some ballots could either inadvertently or deliberately be put on fire. It's not an impossibility. Counting on the same day is modernizing our system. And as I said, this has to be done by regulations. There is no need for a law. And let me end, Madam Speaker. As I say, voter suppression is resorted in many so-called democracies. This is the new trick now. Have elections, but have electoral fraud at the same time. In a democracy, there is no higher treacherous act than stealing an election. We should not forget, la voix du peuple, c'est la voix de Dieu. With these words, I commend the bill to the House.
Again, I need it to be seconded. Yes, Dr. Boulel, yes. Okay, we carry on with the... Yes, Mr. Duval? Everybody will be getting 10 minutes as from now.
Thank you, Madam Speaker. Madam Speaker,
That's my job, part of my job.
Madam Speaker,
Yes.
it is a good thing that we are finally aligning ourselves with other prominent democratic countries, especially, let us not forget, since so many electors have been left out of elections, have been deprived of the right to vote during the past elections, with an S. If we look at 2014, the figures speak of something like 9,000. If you look at 2019, the figures are even more shocking, 45,000. Electors left out, and for many of which did not change their residency. And it was therefore extremely unfair to leave out electors who, in between the 16th of June of the preceding year and the upcoming elections, was not aware or did not verify through omission, through negligence, whether or not they were on the electoral roll. So we are correcting a grave injustice to democracy. And in fact, the PMSD, together with the Labour Party and the MMM, let us not forget, co-wrote and co-signed the letter to the Electoral Commissioner on the 24th April 2023. And in fact, the PMSD has been advocating for keeping the registration of electors, the roll, open up until the last minute, like in the UK. In the UK, as you may know, Madam Speaker, it is up to 12 days before the election. Here, it will be 5 days after the written election. It will be sufficient to catch all those persons who have been left out. But I have here, though, to deplore the fact that although, and I heard the Prime Minister, even though I do apologize, I came in late, was preparing my speech, but I did hear that the reasoning behind this amendment being brought for this municipal election is first of all for the young electors, the young generation of electors who have either turned 18 after the 16th of June of last year or who are about to turn 18 by the time that they are still eligible to be registered on the supplementary register. However, Madam Speaker, we are catering for the new generation with archaic measures. Instead of doing like other countries, of allowing for online registration, as was pleaded by the Honourable Prime Minister, the Deputy Prime Minister and the leader of the PMSD to the Electoral Commission, that online registration of electors becomes a reality. It is a shame that this is not the case, because, Madam Speaker, the systems that we have in place today with MOPAS, for example, which is secure enough to allow, for example, for the civil status office to hand over, to apply and to hand over birth certificates, or for the DPP's office, for you to apply and to receive your certificate of character, therefore very sensitive documents. If the system is good enough for that, it would have been good enough for electors to register. And the system exists. It is in place. It is used by hundreds of thousands of Mauritians, mainly the youth, because let us not forget that participation at municipal elections unfortunately tend to have lower participation, especially from the youth. And now we're going to require them to first call at the local electoral desk to register themselves, and then, of course, after, to go and register. I think there had been sufficient time, since we are contemplating this since as far back as April 2023, we had sufficient time to do so. So that, for me, is une opportunité ratée pour le gouvernement. Madam Speaker, the other issue, le programme le plus important qui a attiré l'attention des Mauriciens dans son intégralité reste le fait que les électeurs, les résidents ressortissants des pays issus du Commonwealth puissent, de par notre Constitution, sont éligibles pour être enregistrés comme des électeurs. D'ailleurs, il suffit de consulter les formes qui restent inchangées sous cet amendement. La forme I, par exemple, si on objecte à l'enregistrement des électeurs, cette forme I ou H parle qu'on peut objecter si la personne, par exemple, n'est pas issue de pays du Commonwealth. Et le bureau du commissaire électoral est obligé d'appliquer cette provision de la Constitution. L'agent du commissaire électoral qui est responsable pour l'enregistrement des électeurs est obligé, s'il reçoit des informations de par la loi, d'enregistrer quiconque qui a acquis le statut de résident, qui a eu plus de 2 ans sur le territoire à compter du 1er janvier, 2 ans avant l'enregistrement, d'être enregistré. Et donc, il peut être non seulement un électeur, mais il peut aussi se présenter comme un candidat aux élections municipaux, ou villageoises, municipales, villageoises ou régionales. Donc voilà l'opportunité ratée de ce gouvernement. On a promis ici de changer.
Excusez-moi, j'ai pas bien suivi le deuxième raisonnement. C'est-à-dire que vous êtes contre.
Non, je m'explique, madame.
Oui, allez-y.
Si je peux m'exprimer.
Allez-y.
Merci. Donc je disais, l'opportunité ratée, manquée encore une fois, aurait été de venir avec un amendement de la Constitution pour changer cette section 42, Qualification of Electors, et retirer cette provision archaïque. D'ailleurs, il faut se rappeler que c'est le PNSD qui a amené ça ici dans la Chambre. Il faut se rappeler, cette provision archaïque qui est la section 42 de la Constitution, qui prévoit bien sûr que suffit d'être ressortissant d'un pays du Commonwealth, et la liste est longue, et on devient un électeur. Et à croire l'honorable Boutim, le manque de main-d'œuvre étrangère, le manque de main-d'œuvre à Maurice, demandant l'importation de main-d'œuvre étrangère, va continuer à accroître ce problème pour les élections d'avenir. Et pourquoi donc, et la question que je pose au Premier ministre, pourquoi donc n'a-t-il pas jugé bon, fort de sa majorité de 64, d'apporter ce simple amendement, simplement amender la section 42 pour enlever le droit à tout citoyen de pays Commonwealth de participer aux élections? Parce que d'enlever le droit. Oui.
C'est ça que
le Premier ministre. Le Premier ministre lui-même a fait campagne. Le Premier ministre lui-même a fait campagne sur le fait qu'on laissait les travailleurs étrangers voter en 2019. Si je ne me trompe pas, ce paragraphe était un paragraphe important de son propre challenge dans sa pétition électorale, notamment le droit des étrangers. Alors, Madame la Présidente, c'est dommage qu'on parle. Le fait reste, Madame la Présidente, qu'avec 64 députés, c'est une occasion ratée. Parce que le changement, c'est pour tout de suite. C'est pas pour les élections après. Vous avez été élu, le gouvernement, pour un mandat de changer les choses maintenant. Il y a eu tellement d'autres occasions, on parlait du collège électoral, ce sera pour après. Tant d'autres choses qu'on a mis reléguées pour après. Et malheureusement, on permettra encore une fois aux ressortissants étrangers de voter pour des élections municipales.
Que ceux du Commonwealth.
Alors,
pas les autres.
I'm sorry?
Que ceux du Commonwealth et pas les autres. J'ai cru.
Mais je parle du Commonwealth, là, Madame la Présidente.
Non, mais j'ai cru un moment que vous vouliez donner aux autres le droit
Non,
de
vous avez mal cru, Madame. Donc ça, pour moi, et là où le bas blesse, si on apporte des changements à à notre système électoral, qu'on le fasse en profondeur. Parce que nous avons, encore une fois, un document du 24 avril 2023.
Je vous donne encore.
De très très bonnes propositions ont été faites. Je suis content d'entendre que le CMD counting, le comptage le même jour, le dépouillement deviendra une réalité. J'espère, il n'a pas été précisé, si ça se fera dans un centre de dépouillement par circonscription. J'espère que ce soit le cas pour permettre non seulement que plus facilement de garder un contrôle sur les boîtes, sur le comptage, quand toutes les boîtes sont emmenées dans un centre de vote, le Premier ministre n'a pas spécifié. Et bien sûr aussi pour préserver l'anonymité des endroits qui ont voté par rapport à leurs intentions de vote. Parce que pour un politicien, c'est très mauvais demain de savoir si telle ou telle école de vote a voté avec ou contre lui. Et c'est pour ça que quand il y a un dépouillement dans un centre de vote, c'est impossible de savoir d'où les ballots sortent. Parce que tout est cassé et mélangé. Mais s'il y a le comptage dans le même, s'il y a un comptage dans les écoles de vote, ce sera très facile. Oui, Madame la Présidente.
Vous avez déjà une minute en plus.
Madame la Présidente, une autre chose, bien sûr, c'est l'importance et l'occasion ratée d'organiser les élections des collectivités locales le même jour, que ce soit pour les municipales, que ce soit pour les villageoises. Ça aussi est important. Pour finir, Madame la Présidente, si vous me permettez de conclure.
Je vous ai déjà donné votre point en plus.
On rattrapera sur la dernière fois.
Non.
Madame la Présidente, pour finir.
You can't bring it over.
Pour finir, Madame la Présidente, c'est dommage qu'on nous a promis un changement, et un changement qui se fait de goutte à goutte. Le changement, ce n'est pas pour cette fois-ci, ce sera pour après. Ce sera probablement par une autre équipe, finalement. Alors c'est dommage que le changement intervient en goutte à goutte et avec une lenteur. Donc merci, Madame la Présidente.
Je vous remercie. Je vous remercie. Honorable Attorney General.
Madam Speaker.
A lot of speech today.
I have listened with great interest to the intervention of my learned friend of the bar, but I think he is labouring under strong misapprehension of what the law says. Commonwealth citizens cannot vote at municipal elections. This bill, Madam Speaker, is in fact a landmark piece of legislation, as this will ensure that qualified unregistered persons will, once registered after the issue of writs of elections for the forthcoming municipal city council and municipal town council elections, have the opportunity to cast their vote at those elections, thus guaranteeing that they are not deprived of their constitutional rights to vote. Of course, Mauritians and Mauritians only. Madam Speaker, many of the orators in this House today will share the opinions on the amendments that are being proposed to this Act. Much will be said on the need for those amendments, and it would greatly surprise me if there is any pushback, since there is consensus amongst members on the advancements of democratic standards. I will not tread the path that many today will take, but rather my opinion on the legal aspects of the bills, especially on the tight deadlines that are being proposed for registration after the issue of writs for the forthcoming municipal elections. Madam Speaker, is clearly spelled out in the explanatory memorandum of the bill the main object of this legislation, which is to amend the RPA, is to provide for a supplementary register of electors for each electoral area, i.e. a supplementary register that will be an addendum to the register of electors already in force for a particular year and for a particular electoral area. Madam Speaker, the idea seems to be very simple, but members of this House will appreciate that this simple amendment to have a supplementary register carries it with it a lot of legal implications. According to Regulation 3.2b of the Municipal City Council and Municipal Town Council Elections Regulations 2012, the nomination day shall be held not less than 15 days and not more than 30 days after the day on which the writs of elections for the holding of the municipal elections are issued. Therefore, Madam Speaker, there is a minimum window of 15 days before nomination day, and during that tight schedule, the office of the Electoral Commissioner will have to ensure that on the eve of nomination day, the supplementary register of elector is published. Madam Speaker, allow me to explain the legal implications. As per clause 5 of the bill, in the proposed new section 39D1, a person who claims to be eligible to be registered as an elector in an electoral area shall not later than 5 days after the issue of the writs of elections present his claim to the registration officer of that electoral area. So if writs are out, for example, tomorrow on the Wednesday 19th of March, the 5 days will extend to Monday the 24th. And I have been reliably informed that the registration offices set up by the Electoral Commissioner will be opened on Saturday and Sunday to ensure full compliance with these provisions. After that preliminary registration exercise is carried out during the prescribed period of 5 days, the registration officer, in accordance with the proposed new section 39E, shall not later than 2 days after the expiry of the 5-day period publish the supplementary list of claimants who appear to the registration officer to be qualified to be registered as electors. The supplementary list of claimants, as they are called under the Act, will be published for public inspection for a period of 2 days, and the reason for same is to allow a person whose name appears on a register or supplementary list of claimants in that electoral area to object to the registration of a claimant as an elector. Any objection, Madam Speaker, will have to be made during the few days of publication, and that is as per section 39F2 of the new RPA, of the supplementary list of claimants. If it appears to the registration officer that the objection is frivolous and there's no merit, he will reject the objection, but in case he admits the objection, he will have, in accordance with the new proposed section 39G, a duty to serve the following day, after receiving the objection, a notice on the person in respect of whose registration the notice of objection is given, calling upon that person to show cause why his name should not be expunged. That person will then have 2 days within which he will have to appear before the registration officer and show cause why his name should appear on the supplementary register. After hearing the objection, the registration officer will have 1 day to decide on the objection, and he will thereafter have to make all necessary corrections to the supplementary list of claimants and do everything necessary to compile that list, so corrected, into a supplementary register. And this supplementary register must be ready at least 1 day before nomination day. As explained earlier, after the issue of writs, there are 5 days for an unregistered person to claim to be registered. However, in case there is no objection, the registration officer will, as soon as practicable, publish the supplementary register. But if there is objection, there are certain procedures to be followed, as we have set out earlier, and from the first day the registration exercise starts, 13 days will lapse until the registration officer decides on the objection. These tight schedules have been rendered necessary so as to respect the 15 days period prior to nomination day. Madam Speaker, the procedures that I've enumerated above are not new. We are not inventing a new procedure for the registration of electors. These procedures already exist in the existing Representation of the People's Act, more specifically with regard to the compilation of registers under sections 9 to 25 of the law. The only difference with the compilation of the register and that of the supplementary register is the time limit provided for objections. And similarly, for the compilation of a supplement register, the time limits are shorter, given that it has to be done at least 1 day prior to nomination day. On another important note, I wish to inform the House that if an objector is still dissatisfied with the decision of the registration officer to include the name of a person whose name has been objected to in a supplementary register, he still has a right under Section 36 to make an appeal to the judge in chambers to have that name expunged from the supplementary register. However, Madam Speaker, as is currently provided with regards to an appeal made to the judge in chambers to have a name expunged from a register, the right of a person whose name is for the time being on the supplementary register to vote at the forthcoming municipal elections will not be prejudiced by the appeal, and a vote given at those elections in pursuance of that right will be as valid and effective as if no such appeal were pending, and shall not be affected by the subsequent decision of the appeal. I have therefore brushed on the legal implications attached to the registration of unqualified persons on the register of supplementary register, and as stated earlier, however, the idea to have a supplementary register appear to be easy, yet there are some hurdles to overcome, and I can assure the House that all the legal implications have been carefully scrutinised and addressed. Last but not least, I wish to inform the House that this process to provide for a supplementary register will not only be made available for the forthcoming municipal elections, but it may also be extended to other elections by prescribing same by way of regulations in virtue of the new Section 39B of the Bill. The Honourable Prime Minister has also stated that there will be same-day counting, and the Honourable Members will have seen that this is not provided for in the amendments proposed to the House today. The reason is very simple. The appropriate amendments will be made to the regulations in order to render this possible. To conclude, Madam Speaker, I wish to draw the attention of the House, and especially to those persons whose name already appear on the register of electors that came into force on 16th of August 2024, that they will not be eligible to have their names on the supplementary register, even if they claim that they are no longer residents of a particular electoral area. This registration exercise will not permit an elector already registered in an electoral area to be registered in another electoral area, as this supplementary register will apply to only those qualified, unregistered electors, more specifically, but not only to those who have attained the age of 18 on or after 16th of August 2024, and for those who will attain the age of 18 one day prior to nomination day of the forthcoming municipal elections. So the claim can be made even before you're 18, provided you turn 18 before nomination day. With these words, I commend this bill to the House.
Thank you for being well within time. Now I will suspend the sitting for half an hour.